Hi, and welcome to the Catalyst Law webinar, the impact of the COVID-19 pandemic on contracts and commercial lease agreements for businesses and nonprofit organizations. I'm Kimberly Prey. I'm a partner at Catalyst, and with me I have Nate Funk. He's the Director of Operations and of Counsel, business lawyer, and real estate attorney. And I also have with us Kiren Rockenstein. She is a business lawyer, also patent attorney and intellectual property attorney, and has her own law firm called Rockenstein Law, LLC. We partner together quite often. So just to brief background, my area of practice is taxation. I do work with businesses quite a bit. I also work with nonprofit organizations. And so I'm here to mostly discuss fiduciary duties related to these contracts and commercial lease agreements for nonprofit organizations, which we'll cover towards the end of the webinar today. And Nate, do you want to introduce yourself and talk a little bit more about your background, and then Kiren, and then we can just dig into the meat of the presentation.
Sure. Welcome, everyone. Thanks for joining us. As Kimberly said, my name is Nate Funk. I am a business and real estate attorney mostly. I handle all types of business transactions, help companies get formed all the way through exit. As I said, I also do a fair amount of real estate, mostly commercial purchase and sale, but also commercial leases. I've done a little bit of residential real estate as well. I dabble in some intellectual property and technology work as well.
Great. Hi, everyone. My name is Kiren Rockenstein, and as Kimberly mentioned, I am an intellectual property attorney. I work with up-and-coming startup companies or early stage companies to help them protect their intellectual property and also help them with all their business needs as they're kind of growing their company and figuring out what they need to do to get all their ducks in a row. And I'll mostly be answering questions on contracts and the impacts of COVID on the need to perform under contracts that you may have going or maybe thinking about putting in place.
Great, thank you. Okay, so we have a corresponding website page that provides some of these frequently asked questions. And Nate, do you want to start us off with an introduction with, we're missing our moderator right now, so I'm trying to come up with what she would have had ready to go here.
Oh, yeah. Let's see. Sorry. I guess, first of all, we should say that this is intended to be educational and informational, obviously not specific legal advice. We'll do our best to answer any questions that you might have, but we can't really answer very specific questions. We'll do our best to give kind of general information, though, and hopefully that will be somewhat helpful. I think on the right side of your screen, there should be a chat box where you can obviously chat and feel free to pose questions. We'll, as we see them, we may answer them if they're relevant to the topic we're discussing. Otherwise, we'll try to address as many as we can at the end. And with that, to get started, I think we'll talk first about generally speaking, whether or not you have to or can close your business during this time. Governor Brown issued an executive order which talked about whether or not you have to close your business or can close your business. For the most part, it depends on whether you are considered an essential business. There's on the State of Oregon website, there's actually a little quiz that kind of walks you through whether or not you qualify as an essential business. And the first question is, are you on the list of businesses that must be closed? And those are pretty much any business that requires a lot of people to be in any given place at any time and interact. So any business that puts on parties or celebrations, restaurants with dine-in, nightclubs, things like that. If you're not in that category, the next question is can your employees work remotely? If they cannot, then the final question is, can you, while working and maintaining your workplace, can you adhere to the social distancing requirements of trying to stay at least 6 feet apart? If the question, or if the answer rather to that one is again no, then most likely you should stay closed. So it I guess really depends on what the nature of your business is, and primarily whether your employees can work effectively from home.
Great, thank you. So what if, how can I terminate or suspend or amend my agreement? Kiren, do you want to speak to that?
Sure. So these are, so the question, how can I terminate, suspend, or amend my agreement, is one way of phrasing the question. Do I need to perform under a contract I'm in, or does the other party need to perform under the contract? So performance in a general term under a contract is an agreement between two people to do one thing in for something else. So typically this means providing a service or a good and payment on the other side. Now, obviously, with everything that's been going on, if you're trying to provide a service for an event that was on a particular date or that required certain goods that you are no longer able to source for whatever reason, people are looking at ways to try and look at the contract to see if they have a way of either getting out of that contract or suspending or pausing the need to do what they have agreed to do under that contract. It really depends on the nature of the task that you were contracted to do and the specific language of the contract itself. So many contracts will have certain terms in there that address what happens if there's an unexpected event or an unexpected change in circumstance. One very common clause that's in these agreements is something that's called a force majeure clause. This is basically some language in there that says if something happens that is unforeseen and unrelated to the parties and something that they couldn't have controlled for, it provides a mechanism by which the contract can either be terminated or suspended. So as with most things in a contract, it's very specific to the language in that particular clause and very fact specific to the situation that you're in. So typically you'll see things like acts of God or fire, civil unrest, riot. And if any of these events occur, it gives the potential for the party that's supposed to perform under that contract to either no longer perform or suspend their performance until that event is either over or they reach a situation where they can continue to perform even if that event is going on. As I mentioned, the specific language of the clause itself is going to control what your rights are here and what the rights of the other party are here as well. And the other things to look out for are not just the specific events that have been called out, but also what your responsibility is. So many of these clauses will ask you to provide notice as soon as you know that you can't perform. They may straight out allow you to suspend or terminate. They may require you to just put it on pause and then keep checking in at a certain period to see whether performance is now possible. So really any analysis of the contract and your obligations depends, as I said, it's very situation specific and it just requires a deep understanding of the specific language that's in the contract itself. There are other terms that could also be relevant here. So in financial agreements where you're agreeing to buy a company or sell a company, there's a clause that's known as a material adverse events clause. And again, similar to the force majeure clause, it's very fact specific and very language specific on the clause itself. And there are other mechanisms such as frustration of a contract or impossibility or practicality, which also allow you to suspend or terminate your performance or allow the other party to do the same, because obviously the contract is written between the two of you. So those are other areas that you could look at to give you some legal standing for trying to alter your performance under a contract. And it's not always necessary to cancel. The other options that you have are modifying the contract in a way that works for both parties to continue the work in whatever capacity it can be. And you can also renegotiate to see if performance can be changed in a way that can be agreeable to both sides. So practical steps, I think, here would probably be looking at the language of your agreement, or having someone with a legal background look over the language of your agreement for you, and really analyzing the situation that you're in, and also just keeping open lines of communication with the other side, especially if there are notice requirements or regular check-in requirements, so you can keep everyone informed as to what's going on.
Great. And so in the case that I've already paid or delivered and the other party cannot, what are my options?
So an example here would be something like, I don't know, you ordered a cake for a wedding or something, and the cake has been made, but the wedding can't go ahead. And if the other party has done the work, they can expect payment. Now, again, this might be something that you can negotiate. You can set up a payment plan or set up, some other way of getting them their money. But if someone has performed under a contract, then they are entitled to payment under the contract.
Right. We have a comment here. It seems like passing the test for terminating the agreement is the most secure footing to stand on for potential modifications to a lease or a contract. Do either of you want to speak to that?
Sure, I can add to that. So in a way that's kind of right. Like Kiren said in her comment, a lot of it depends on obviously what the contract says. It also depends on where the parties are in kind of the timing or the life cycle of the contract. If you've just signed a contract and nobody's done anything or done much as far as committing resources to it, whether that's providing some type of good or service or paying money, obviously it's a little easier to terminate. There might be, depending again on what type of contract it is, there might be an opportunity for you to terminate at any time without much penalty or without any penalty. But in a case, as Kiren mentioned, where one party has already delivered the goods or services, and due to the current situation, you don't have sufficient funds to pay, or you'd like to find a way to at least defer that payment. Typically, there's not any option in the contract for you to do that. Obviously, with any of these issues, I think it's always worthwhile just to contact the other party and talk to them about what the situation is and figure out a way around it. I don't think anybody really wants to strike up a lot of litigation over what's going on right now. But so finding a way that works for everyone, maybe you can defer payment or agree to a payment plan. That would certainly be better than either just ignoring them or telling them you can't pay and trying to figure out a way around that. If you're on the other side and you've already paid money and are waiting for the delivery of goods or services, again, there's, if you've already performed your part, there's certainly an expectation that the other side has to perform their part eventually. They either might not be able to now, or for a number of reasons might not be able to do so either effectively or the way you expected them to. So again, reaching out to them and having a conversation about when that might happen, or whether they can issue a full or partial refund, or again, return the money on a payment plan or something. Figuring out how to do that, and no matter what, I think you figure out, of course, if you come to some type of agreement or alternative arrangement, always documenting that in whether it's a formal amendment, but some type of written document that the parties can review and sign, so you have something to go back on. If obviously nobody really knows exactly what's going to happen in the near or the distant future, so making sure you document that so the parties have a way to look back and say this is what we agreed to, and and structure, however that, whether it's a deferment of payment or that, services will be provided at some point in the future. Having that written down would certainly help avoid any confusion or misunderstanding going forward.
Great, thanks, Nate. A lot of questions have emerged around the force majeure provisions in contracts. And, can you describe what those provisions are a little bit more in detail, and if there's other options if your contract doesn't have that provision or the provision doesn't include this current situation?
Right. So force majeure, it means, I guess it's French for a superior force, and it's generally included in a contract as a way, I think, as Kiren mentioned, to give one or possibly both parties either an excuse for not performing or a way to delay or suspend performance if there's some type of unanticipated and uncontrollable event or circumstance that makes performance impossible. And again, it all depends, as Kiren mentioned, it all depends on what the specific provision in your contract says. There's no sort of standard provision, so there may be, some of them include a long list of the types of events, some of them include broader categories, some of them just might say any uncontrollable event. So really looking at it and figuring out what it says and whether this particular situation is covered is a key component of that. And then what it provides you as far as, if assuming it is or might be covered, what it provides you as far as your right to, it might allow you an opportunity to either terminate the contract or excuse your non-performance altogether. It might just suspend it until the event or circumstance is over. And in either event, there's a good chance that you have some obligation to notify the other party of the issue, and perhaps even an ongoing obligation to continue to update them on the status of your ability to perform. And there may also be an obligation for you to, even if, assuming that this current pandemic would qualify under some force majeure clause, there may be an obligation for you to investigate and consider alternatives to performance. Maybe it's partial performance, or if you have certain delivery obligations, rescheduling those and trying to figure out ways to somehow make it work. It's not, it's certainly not an easy out. There's typically a lot of requirements and a lot of things that you have to show or to prove before it will fully excuse your performance or lack of performance. So the first thing to look at is if there is even a provision in your contract. Oftentimes there's not. They can be found fairly commonly in longer agreements. A lot of shorter service contracts and things, invoices, and other terms don't include force majeure clauses. There might be some language, some similar language buried in some other provision, but to see whether or not it's in there, I guess, would be the first step. The next step will be to figure out whether the current COVID-19 pandemic even qualifies as a force majeure event. Again, there's any number of combination of lists of events that might appear. As I was preparing for this, I made a little list of the different events, and there's probably almost 100 different things that can appear in there, all the way from nuclear catastrophes to civil war, to more common things like changes in state or local laws or acts of government. There certainly are some that might include the specific word pandemic or some kind of disease or health issue like that. I think those are probably less common. So hoping that if there is one in your contract, it includes some kind of catch-all language or more broad or general language that would refer to some uncontrollable event. And another key aspect of it is it has to be something that was unanticipated or that the party didn't think about and allocate risk for beforehand. In this situation, I think it's highly unlikely anybody, 6 or 8 months ago would have anticipated this type of event. If you entered into a contract in January or February, there might be an argument that this was something that could have been anticipated or expected, but that would be an argument you'd have to have, in a court. So again, it's not really an easy out, but looking at it, and if you think it's covered, it might be something to use in your conversation with the other side, trying to figure out what the best way forward is. And again, whether or not this type of provision is in your contract, I think contacting the other party and figuring out a way to move forward that for both parties is probably the best solution. There's obviously a good chance that there's very few industries or businesses that haven't been affected in some way by the current situation. So there's a good chance, even if their situation isn't quite as bad as yours, there's a good chance that there's an opportunity to work something out that will benefit, or at least not be to the detriment of both parties. If your contract does not have a force majeure clause, and again, many of them don't, there are a couple other options that might help you. There's a concept called impossibility or commercial impracticability. Both of those they don't have to be in the contract itself. Those are what are called common law principles that are available to anybody. But both of those, as well as frustration of purpose, are available, but they're also incredibly difficult to use successfully. Impossibility in particular requires that your performance must actually be impossible. It can't just be extremely difficult or extremely even prohibitively expensive. It must be literally impossible. So that's obviously a very difficult one. The standard for impracticability is a little lower, but still it's a pretty high standard. So I certainly wouldn't, obviously it depends on any given circumstance or any given situation, but I wouldn't, those are two I probably wouldn't want to rely on very heavily if I was trying to get out of a contract. But they are certainly things to keep in mind or in the back of your mind. And there certainly may be people out there or businesses out there that those might be options if their performance is literally impossible due to the current situation.
Great. Thank you, Nate. So we have a comment here about a lease. We're going to get into commercial leases here. So hopefully we'll cover that question. And also there's a comment, since we don't have precedent, then groups can interpret COVID as they see fit. Is that a good summary of what we're going to see going forward?
Yeah, and that's certainly one issue with, as I mentioned, there's not every contract includes force majeure provision, and for understandable reasons, they're not something that gets litigated or argued about very often. And this is certainly an unprecedented situation. And so trying to figure out whether or not this would apply is not an easy task. Obviously, if your force majeure provision specifically include pandemics, that would be much more likely. But if it doesn't, it's a difficult analysis and would really depend on exactly what the situation is, what your type of business is, and how exactly how it was affected and how it affects your ability to perform. But there really is no. This isn't something that we've seen before, or really not only this particular situation, but something of this magnitude. So it's difficult to know how it will be viewed. I have to imagine there'll be some litigation about it in the coming years, but I don't think we're going to find out a certain answer anytime soon.
Great, thanks for that. So I guess, Nate, this is also a question for you with your real estate background. What if I just can't pay my rent?
Right. So if you're unable to pay your rent or are concerned about being able to pay your rent going forward, one option is the Governor Brown issued an executive order, I think it's 2013, that talks about, or that puts a moratorium on commercial, also residential evictions, but for our purposes, we'll focus on the commercial evictions. It puts a moratorium on terminating any commercial lease or evicting any commercial tenant for the non-payment of rent. Their tenants or leases can still be terminated, and tenants can still be evicted for other causes outside of anything related to payment of rent. But at least from now until June 30th, I think, is the current expiration of the moratorium. A landlord can't evict you or terminate your lease as a result of non-payment of rent. At the same time, you can't just, or you shouldn't just stop paying your rent. There are some requirements in the executive order that, one, that you should contact your landlord before the rent is due and discuss the situation with them, and then provide some documentation to support your financial hardship or to at least demonstrate your difficulty in paying rent. And I think either way, a more important aspect of it is, at least for now, it expires. It's set to expire on June 30th. My guess is it'll either be extended beyond that, or there'll be some more clarification on exactly how the situation will be handled. But currently, as I understand the executive order, the moratorium lasts until then, but you have to repay the rent, any rent that you missed once the moratorium expires. So it's not waived. It doesn't waive your requirement to pay rent. It just defers it for a period of time. So obviously, if you can't pay your rent, then you should certainly take advantage of the fact that you don't have to pay it in the short term. But you will have to figure out a way to pay it, at least under the current executive order, within a few months. So even if you want to take advantage of the moratorium, obviously it requires you to contact your landlord and let them know either way. But in the clients we've talked to, we certainly recommend that you contact your landlord and talk to them about the situation, and ideally come to an agreement about how to handle any rent that's missed, and hopefully either defer that out longer or stretch it out into a payment plan, or figure out some way to manage that beyond June 30th. At least, again, that's the current date. That is I have to think likely to change, or Governor Brown might come up with some more clarification on how that will be handled. I think, and I may be wrong, but I think the residential, at least for the city of Portland and Multnomah County, I think the residential moratorium is similar, but I think it gives up to 90 days after the moratorium expires to repay the unpaid rent. So they may do something similar in the commercial context, but in the short term, at least for peace of mind, it might be helpful to contact your landlord, negotiate some way to defer that rent out, and also spread out the payments, or defer, give yourself, whether it's 60 or 90 days to repay those. And again, and you might also want to include something in there to say if that date changes, or if the situation changes, you can revisit it.
Great. Thank you. I know that's a really common question these days, and it does seem like we'll just have to keep being in good communication with the landlord and working together. A lot of landlords have been quite understanding during this period, and I think that's definitely the first approach that we recommend.
Yeah, and one other thing to mention in the order, it also, so they can't terminate your lease or evict you for non-payment of rent. They also can't charge any late fees or interest or anything on any payments that are missed, again, through that expiration of that moratorium. So if you're unable to pay, you at least have that grace period, so to speak, of not having to pay rent, but also not having to pay interest or fees on any of that. And hopefully you can either work something out with the landlord to push those payments out, or the state of Oregon will come out with some guidance on how that will be handled going forward.
Right. If your landlord is not cooperative and is adversarial, do you have any tips or recommendations on how to do that, documentation and otherwise?
Yeah, hopefully, landlords will be somewhat cooperative, and again, everybody's kind of going through the same thing, so there's hopefully an opportunity to work something out. But at the same time, landlords have bills to pay as well, so they may be either unwilling or unable to, for some reason, to push those payments out any further beyond that. Either way, whether you can agree to something favorable or helpful, or if they're unwilling or unable to, I certainly recommend documenting it in some way. If they're not willing to sign something, an amendment or an agreement with you to say that you're going to push it out, then having something, whether even email would be fine. I think to send them an email to confirm. If you have a conversation over the phone, follow up with an email confirmation saying, if you wouldn't accept this, or you couldn't agree to this, but here's what we plan to do. And in that case, you'd probably have to fall back on the moratorium and just provide, make sure you understand the requirements in the moratorium and what you have to provide, the notice and the documentation, and make sure you're doing what you need to do. so there's no argument on their side that you failed in that regard.
Mhm.
And just be as clear as you can and with that documentation and your position, and do the best you can to figure out how you'll be able to pay it when the time comes due.
Right. The other thing to keep in mind is that the stimulus dollars, with the caveat that they're a lot more difficult to come by than originally planned, 25% of the PPP loan and the EIDL loan advance can be directed towards rent payments. So that's a resource for both tenants as well as landlords to educate your tenants about the opportunity. It is likely, not a sure thing, but likely that more stimulus dollars will be coming through the federal government. And so, that support for small business owners will continue to be an option. And that's another way to work with your landlord, is just keep them informed about what resources you're pursuing, any types of funding that you're going after, and just paying attention to the timeline and keeping up with when those resources may be available to make those payments. So and that will also hopefully come in before the June 30th deadline when the moratorium expires. One question that we wanted to discuss is, what happens when business partners have to go in together and contribute your own capital to keep the business afloat during this time? And then, what if one partner out of, maybe two or maybe many just can't make those capital contributions? What are your options? And so the first thing to do is go to your operating agreement. It usually has some specific language around whether or not capital contributions can be imposed on partners, or whether or not they're required in certain circumstances. If you do not have an operating agreement, then, again, I think the best thing to do is just talk amongst yourselves in terms of what options that you may have. Business disputes between partners can get very expensive, and the best thing to do is kind of keep your cool and try and work things out, rather than resort to litigation or any adversarial type position. The last thing that the last thing that we want to see is business owners spending money fighting each other, rather than getting back to work and doing business. So Nate, do you have any other tips there with contributing individual capital?
Yeah, I mean, I think you touched on all the key points. I think similar to anything else we've talked about, whatever you end up agreeing to, or however you end up resolving it, is to make sure you document it. All too often, disputes arise not only from an initial disagreement, but in either a misunderstanding or disagreement about how it was resolved to begin with. So if you can reach some type of understanding, whether it's one party contributes some funds to the company, make sure you document that and how it'll be handled, whether it's considered a loan or an additional capital contribution, and how that affects each of the partners' capital account, or how it will be repaid and when it will be repaid. So making sure to document all those things, and of course, speaking to your accountant to make sure you understand all the tax implications and other things for how that money will be handled. And either way, like I said, making sure you document it properly, and both parties kind of understand how it will be treated and handled, so there's no second disagreement down the road when you look back to try to figure out how to, when hopefully things, when we get on the other side of this and things turn around, making sure that you get your money back, or the business handles that in the appropriate way.
Great, thank you. So I want to touch on, just for the nonprofit viewers out there, I wanted to touch a little bit on the difference between, we just talked about business partners, shareholders, or members in an LLC. When you are a nonprofit director, there are certain duties that you have, and you want to make sure that you're acting in accordance with, exercising those fiduciary duties. The first duty you have is the duty of care. So that means that you need to operate with the care that a ordinary person would exercise under similar circumstances, and in a manner that you reasonably believe to be in the best interest of the nonprofit organization. So, in other words, that really means that you must be informed and you need to act in good faith. So if you are a director on the board of a nonprofit that may be going through some, financial challenges right now, it's really important that you stay involved, that you review financials, you ask for financials, you make sure that you're paying close attention to the recommendations, decisions that the board and the executive team may be making. The business judgment rules provides that as an officer or director, you're protected from liability if you exercise reasonable business judgment. So even if the decision turns out to be an error, you're protected if you're reasonably informed and you make those decisions in good faith in order to qualify for protection under this rule. If, on the other hand, you don't ask questions, you don't review financials, you try and multitask during teleconference board meetings and miss a lot of information and just go along with what somebody says, then you have less to rely on when it comes to potential liability under that business judgment rule. Regular attendance at those board and committee meetings is very important, and you want to check your bylaws for and your articles for an indemnification provision, making sure that if the organization runs into trouble and under some kind of under maybe a breach of contract or any other potential liability, that the organization has an opportunity to pay for your legal expenses. This gets complicated as well because you want to look to your insurance policy, your directors and officers insurance, and make sure that you're covered. And in the case that the entire organization and every single director on the board is party to litigation, that the organization's directors and officers insurance actually covers the entire, the amount of those legal fees. The duty of loyalty when you're on the board of directors is really meaning that you need to put your self-interest or the interest of another person aside and act only in the best interest of the corporation. And that includes confidentiality. That includes paying attention to conflicts of interest and making sure that you avoid private benefit, private inurement. Sometimes when smaller organizations run into financial problems and there are directors that have control of the purse run into financial problems, you might start seeing, increasing chances of embezzlement. So that's also something to pay attention to during the next few months as a director. And then, you have a duty to comply with the organization's articles of incorporation and the bylaws to continue to carry out the exempt purpose. And so those fiduciary duties are important to always remember. In Portland, we have a really high degree of volunteerism. A lot of people serve on boards, and right now is a really important time to be paying particular attention to your board service. The relationship to the executive director or employees, if nonprofits have those, is that the board of directors is responsible for adopting and approving policies governing the organization, major transaction material matters, assessing the performance of the executive director, supervising the day-to-day management, making sure that you're getting reports directly out of the staff, and just paying attention to make sure that that things are not getting into dire circumstances. If you do see red flags, a lot of people are very passionate about their nonprofit service. We really recommend that you get legal counsel and counsel from a CPA to determine what your options are, because the last thing you want to do is get into any kind of litigation over decisions that were made that were not in accordance with that business judgment rule. So with that, just want to open it up for questions. Let's see. We've got them over here. So questions that came in before the presentation. One, are there any new legal options to end a lease prior to the termination date?
I'll take that one. So unfortunately, I think we covered all of the, we already covered all of the potential options there are to terminate a lease. Obviously, again, the first step would always be to review the lease. If you just signed your lease, there might be an option to terminate if the landlord can't deliver the premises in the condition that you expected it in, or if there's something else that prevents you from actually occupying the space. Otherwise, if there's a force majeure clause in the lease, then you should certainly look at that. Or depending on what your specific business or purpose for renting the space was, there might be an opportunity to make an argument for either impossibility or impracticability. If you're, for example, if you just rented a new space to open a restaurant or bar, those aren't really allowed to operate fully. So there might be an argument there. I think all those would be fairly difficult arguments, and there's at least from a general perspective, not knowing the specific terms of any given lease, unfortunately, there isn't any way to just cancel or terminate, even given the current economic and social situation.
Great. Another question is, if force majeure clause seems written only to given out to the landlord, is there any potential relief there for a renter?
So I can kind of take this one. It ties in very closely to what we've discussed before about the force majeure clause. It says, you need to look at the language of the clause itself and what events it calls out, and if it doesn't call out any events, what procedures need to be undertaken. It's fact specific and situation specific. And as Nate mentioned earlier, even if you don't have a force majeure clause, there may be other mechanisms by which a renter may seek an out under the agreement, but those are probably going to be more difficult arguments to make. And again, it just depends on what the content of the contract says and what the specific situation is. So Nate has spoken about the moratorium, and that specifically applies to rent payments and late payments and things like that. But if the situation is something other than that, the moratorium may or may not be relevant, and then the language of the contract will control.
Okay. And Nate, can you talk a little bit about what it's like to, work with an attorney? What your process is, how you approach contract disputes, maybe some tips and tricks that you recommend, when someone's getting into, a potentially adversarial situation.
Yeah, I'd be happy to. So first, I guess I'll start with just some general guidance or tips on how to handle any type of dispute or disagreement with another party to a contract. I think first, obviously, reviewing the contract and making sure you fully understand or are clear on your obligation, your rights and obligations under the contract. So a right being anything you have the ability or have the option to do, and an obligation being something that you have to do that the other side's expecting you to do, some way you have to perform or something that you have to provide. Making sure you fully understand how the contract looks from your perspective as well as their perspective, and figuring out identifying what the issue is. And then oftentimes a contract will include specific language about what happens if one or the other party cannot perform or fails to perform. And it may be a full failure. Maybe they haven't delivered any goods or services or haven't paid any money. If it's some type of partial performance where they've either paid a part of the amount or delivered some of the goods or services, or delivered inadequate goods or services, depending on how the contract's written, there might be an opportunity for you to, you may have an obligation to give them notice within a certain time that you don't think their performance was adequate, or you reject it for some reason if the goods that they've delivered perhaps aren't what you ordered or aren't adequate for some other reason. So make sure you fully understand what obligations you might have, even if the other party is the one that messed up, so to speak. You may have obligations that you have to meet or satisfy before you can rightfully complain. Either way, though, I think as we've mentioned before, contacting the other party and talking to them about it and trying to figure out a way to move forward that works for both parties is always a good first step, especially if it's a business or a business partner that either have an ongoing relationship with or would like to have an ongoing relationship with going forward. Trying to build that goodwill and figure out a way that you can resolve it without involving attorneys if you can. If you do reach that, I guess, unfortunate step where you have to contact an attorney, the first thing we typically do is obviously we want to get a better understanding of who you are and what your business is and what you do and what your primary purposes and goals are for resolving the dispute. Also, we'll take a look at the contract and try to make sure we fully understand what your rights and obligations are as well as the other side's. Depending on where we fall after that, we may recommend that you go back and try to work something out with them directly, or if they have hired legal counsel as well, we can handle those negotiations. And again, our goal is always to resolve things short of litigation. Litigation gets very expensive very quickly, and I guess right now the courts may not even be open for litigation, but trying to figure out a way to resolve that dispute without spending too much money on legal fees is always our goal as well. And our clients obviously share that. So typically there's a way you can work it out. It might not be ideal for you or for the other party, but typically there's a way you can work it out. And again, whether it's agreeing to some kind of delayed or deferred performance or payment or some way, and the contract itself might even specify what happens in the event of a default or non-performance. So if that's not an option you're in love with, then you can certainly try to negotiate something else and figure out a way to move forward and either preserve that relationship or at least avoid some kind of unknown situation where you end up in a legal battle.
One thing that came to my mind, we're seeing a lot of agreements being made by text message these days, email. So how, if you do not have an official contract or, you just made a, handshake deal, either written or unwritten, how do you handle disputes under those circumstances?
Yeah, unfortunately, at least from our perspective, that happens way more than we'd like to see. But we also know that it's fairly common, especially in certain industries. So ideally, there'd always be some type of written agreement that includes all the key and most important terms that govern the relationship of the parties and what each party is supposed to do and when. If that document doesn't exist, hopefully there's at least enough documentation, whether it's emails or even text messages, that can demonstrate what the terms were, that there actually was an agreement. So part of it depends on what the nature of the disagreement is. If one party thought there was a contract and the other party doesn't agree, then trying to establish that there was actually an agreement would be the goal. Or if there is an agreement but you disagree on what the parties were supposed to do and when, then again trying to piece together those communications and figure out if you can identify what those are is the goal. there doesn't have to be a written document like we think of a typical legal contract that's on paper and has a signature on it for it to be legally binding. You can make oral, with a few exceptions, I guess, you can make verbal or oral agreements. You can make agreements over email or even text message, as long as both parties understand or intended for that to be a contract. And that's, at least the key terms are there. So an objective observer could say, there's a contract here for one party to do this and the other party to do something else, then that will suffice. Obviously, proving that or providing evidence that existed gets more and more difficult as you get further away from some type of documentation. So ideally, even if you have exchanges with another party over text message or whatever it might be, following up with an email confirming the nature of your agreement is a good practice, or somehow trying to document it to make sure both parties are on the same page with what everybody is supposed to do.
Great, thank you. So, I think there's some folks are still on. We're happy to take questions. I'm not seeing anything in the chat right now, but as questions come in, we're happy to spend some additional time taking questions. We can't really answer anything very specific to your circumstances, but again, we're happy to take your questions. Generally, we're available for a free 15-minute consultation, and can let you know whether or not you have a matter that we can help you with. Again, this webinar is not intended to be it's not intended to be specific legal advice. It's intended for education purposes only. We've done our best to answer questions, but none of it should be interpreted as legal advice. If you do need legal advice, we are not your lawyers unless we have an engagement agreement. Right now, we're offering a hour-long consultation, which will credit towards any legal fees if you hire us for a project. We're offering that for $199, which is a significant discount for most of our attorneys' hourly rates. Again, happy to talk with you in a free 15-minute consultation, but probably not giving out legal advice during the 15 minutes, just understanding whether or not we could help or providing you with additional resources. We have FAQs that are on the website, and we're coming up with new ones daily and weekly. So check back with us there. And if you'd like for us to keep you on the list for previous or future webinars, please do let us know. If you want to opt out of any mailings, please feel free to do so. We don't share lists with anyone. Thank you very much for attending. We appreciate it, and we hope this helped. We know that everyone's really dealing with these unprecedented circumstances, as are we as law firm owners. So we just want to know that we're here if you need us, and hope that you'll get in touch. All right, thanks so much.
Thanks,
Have a
everyone.